Okay, now we continue. New paragraph. The burden of proof I repeat, the burden of proof, and you should remember what that means. The burden of proof in civil law is on a balance of probabilities. Do you remember what the balance of proof in criminal law is? I wish I could hear you. I hope you've said what I think you said. So the burden of proof in civil law is on a balance of probabilities. Now I explained the difference. In criminal law we had beyond reasonable doubt, which means the level of proof in criminal cases is much higher than the level of proof in a civil case. Okay. You have to prove in a criminal case beyond reasonable doubt. So if we have seen or heard cases involving murder, manslaughter and so on, if the police who did their investigating at the very outset, if they were negligent, if they did not secure the area, the murder area, let's say, the room, the garden, whatever, if they did not secure the area, if they did not wear their protective clothing, you see these forensic scientists, when they turn up, they tend to wear their white gowns, their shoes are covered, their head covered, everything is covered in a particular material which does not leave fibre in the vicinity of the crime or the offence. It has to be exactly as it was. So the police's duty is to get to the crime scene, make sure that it's secured. Nobody goes in and nobody goes out until they have investigated. Now, the police will take certain evidence. For example, if there is a weapon, they will search, they will take the weapon, they will secure the weapon in a particular plastic bag, a plastic bag which will not become sweaty, will not add, heat and therefore change the consistency of the weapon. Whereas if it becomes wet and sweaty, then obviously it could change the consistency of saliva, of blood, or any of that. So everything is generally secured pretty much. So when the forensic scientists move in, or the detectives move in, then whatever they are faced with is exactly as it was when the crime was committed. Which means it is absolutely vital that immediately after an incident, the area is secured. The evidence is preserved, because it's this which makes an offence, which causes a conviction, or the offender walks free. If the offender, for example, if you can't rely on the evidence which was gathered, either because the evidence was tampered with, it could have become contaminated, the officers involved did not wear gloves, maybe they were, immature, well, I shouldn't say immature, inexperienced, or probably just couldn't care less, whatever. If the evidence is tainted, then when you come to rely on that in a criminal court, chances are proving beyond reasonable doubt is almost impossible. it doesn't necessarily mean that the offender is innocent. It just means that you cannot prove beyond reasonable doubt, you cannot rely on the evidence you've got to prove beyond reasonable doubt to cause or to get a conviction. So it's not necessarily, it doesn't necessarily mean that the offender is guilty or the offender is not guilty. It just means that the burden of proof in criminal cases is so high that you have to prove beyond reasonable doubt. Now, the opposite, well, not the opposite, but in civil we have slightly different level of proof. The burden of proof in civil law is not to such a high extent. You don't have to prove beyond reasonable doubt. You only need to prove on what is called a balance of probabilities. And probabilities here is the operative word, because if you can prove in a civil case that it's more probable that what you're saying occurred than improbable, if it's more likely to have happened as you said than unlikely, then chances are you will win in a civil claim. So it's easier to prove civil claims than it is to prove criminal claims or criminal cases. And just to probably use a very old case, but perhaps a case that is known across the world. So if I say to you, for instance, the case where some years ago, many years ago, an American case I will refer to, because American cases are televised and therefore it has more of a worldly knowledge than, let's say, a Canadian case or even an English case. But I'm going to use the American example of a criminal case which involved an offender called, or an accused called O.J. Simpson. Now you may remember many years ago people were glued to their TV sets because this was a case of murder. He was charged by the police with murdering his ex-wife and his ex-wife's new partner. Now, the police at the time claimed that they are only looking for one person, and that one person was O.J. Simpson. Now, there was a history of Mr. Simpson apparently being violent, verbally abusive to his ex-wife. There were tape recordings of her phoning the emergency services. They taped her cries for help. She said on tape what he was doing, and the state that she was in reflected that it was quite a threatening situation that she was confronting. So there was some history in relation to that couple's partnership. So when she was murdered, the police made a statement that they were not looking for anybody else other than Mr. Simpson. When they eventually found him, they questioned him. First of all, they arrested him, they questioned him, and they charged him. And it went to the criminal courts, and as you all know, he was acquitted. He was found not guilty because of certain evidence. There was no, for example, there was no murder weapon which was found. His DNA and maybe aspects of, clothing or whatever was found at the murder scene. But again, that can be argued that he visited her on occasion. So to all intents and purposes, it's not a great mystery why his footprints or fingerprints or clothing fibre would be found at the murder scene. Does not prove beyond reasonable doubt that he was there with the sole intention to carry out a murder. So anyway, that carried on and he was found not guilty. The burden of proof could not show conclusively beyond reasonable doubt that he was the one who committed the act or acts. So he was acquitted, he was found not guilty. The family of the accused the family of the victim, of his ex-wife, felt that Mr. Simpson was not innocent. He had something to do with this particular act, and because he walked away from the criminal courts as a free and innocent man, the family of the ex-wife felt that he was responsible for something. Her death, whether directly or indirectly. And so they decided to bring a civil claim against Mr. Simpson. So they sued him in the civil court as being responsible for the murders, or the murder of, because it was only, as far as I'm aware, it was only the ex-wife's family who made the claim. I'm not aware that her partner's family did the same. They may not, I don't know. But speaking from the ex-wife's family's point of view, they sued Mr. Simpson in the civil courts for compensation because he was responsible for the death of the daughter, the ex-wife. And they won, simply because they were able to prove on a balance of probabilities that the way he acted with her on previous occasions, it was deemed that he was violent, it was deemed that he was temperamental, he could lose his temper at the drop of a hat, he would hit her, she had bruises, and all of these from the medical evidence and the police reports when they were called to the home by the ex-wife on previous occasions, all of these pointed to the fact that he was a very volatile person. Now, they did not have to prove beyond reasonable doubt that he was guilty of murder. They only had to prove on a balance of probabilities that he was responsible for the death. And as a consequence of the evidence which they presented, the court ruled in their favour. And the court ruled that yes, on a balance of probabilities, it is more likely that Mr. Simpson had something to do with the murder of this ex-wife. And they won their claim. Did they get compensation? Well, as far as I know, they're still waiting to be compensated because Mr. Simpson claimed that he was bankrupt. His monies went to pay his legal team and so on and so forth. He was not able to work and therefore he could not pay the level of compensation which was awarded to them. So that's the difference between taking a court case in a civil aspect or the criminal aspect. Criminal, you prove beyond reasonable doubt. Civil, you prove beyond, or on a balance rather, on a balance of probabilities. So that's your basic difference. And also another difference, we have the civil code governing civil cases, and we have criminal code governing criminal cases. Criminal code based on common law system, civil code based on the rules of civil procedure, which, as I said before, are not a rigid set of rules. They are basic general rules which you can apply to a case which is a divorce or breach of contract or personal injury or any of these cases that we will see in the civil system. Okay, so the burden of proof in civil law is on a balance of probabilities. New paragraph. The two parties involved are plaintiff or claimant. Now, in some provinces, we refer to them as plaintiff. In other provinces, we refer to them as claimant. So when you see, for example, in Ontario, it's plaintiff. In British Columbia, is claimant. or is it the other way around? So basically it's the same. They are called plaintiff or claimant. Okay, so the parties involved are plaintiff or claimant, who initiates the claim, so plaintiff and claimant who initiates the claim, and defendant, you have seen this before, and defendant against whom the claim is made. So just to repeat, the parties involved are plaintiff or claimant who initiates the claim, and defendant against whom the claim is made. Full stop. In an appeal, they are called appellant, and we have seen this before. In an appeal, they are called appellant and respondent. Full stop. So of course the appellant is the person who is making the appeal, and the respondent is the person who is responding to any appeals. Okay, so we have a civil code, rule of civil procedure. In fact, I will just go back and repeat what I've said. Civil law aims to compensate a victim with an award of damages. It covers disputes such as breach of contract, personal injury, matrimonial causes, which are divorces, landlord and tenant disputes, and so on. Civil law is deemed private law as it concerns matters between private individuals. Civil law relies on a set or a system of written rules called the rules of civil procedure. Judges do not develop law as in the common law system, but rather they rely on the code itself to interpret cases. The civil code is not a rigid set of rules, but are general rules which can be applied to different types of cases. The burden of proof in civil law is on a balance of probabilities. The two parties involved are plaintiff or claimant, who initiates the claim, and defendant, against whom the claim is made. In an appeal, they are called appellant and respondent. Appellant is the person who appeals, and respondent is the person responding to the appeal. Okay, leave it there for just a second, and when we return, we shall continue. See you in a moment.